Okay, this is Sanitation Strategies LLC versus Troy Livingston and Rochester Midland Corporation, docket number 19-803CB. And on the schedule this afternoon, I have 3 motions. 2 of them are plaintiff's motions for protective order, and the third one is the plaintiff's motion to modify the scheduling order. And first, if I could just have appearances for the record, please.
Thank you, Your Honor. Dean Pacific on behalf of the Plaintiff Sanitation Strategies.
Good afternoon, Your Honor. Scott Eldridge on behalf of defendants.
Good afternoon, Your Honor. Erica Drew on behalf of defendants.
All right, Mr. Pacific, if you want to go ahead whenever you're ready.
Thank you, Your Honor. I'll address first, I guess, kind of in the order these were filed, in the order you mentioned them, our motion to request a protective order regarding defendants 1,722 requests for admissions.
Okay, yeah, I meant to say that that's the order that I was going to go in. Go ahead.
Thank you, Your Honor. You know, I've been practicing law in Michigan for almost 25 years now, and I just frankly have never seen anything like this set of requests for admissions, and frankly, nothing close to it. This thing runs over 350 pages and has over 1,700 requests for admissions. As a frame of reference, as of January 1st of this year, the Michigan Court Rule Amendments put a numerical limit on interrogatories, and that number is 20. Now, obviously, that rule doesn't technically apply to requests for admissions, but I think it gives us a sense of what the drafters of the rules think is an appropriate amount of written discovery. And here the defendant served over 1,700 more requests than that. And so there's really 2 aspects to this, I think, Your Honor. I mean, the sheer volume, just ridiculous volume on its face here, I think lays bare that the intent here was just to harass and annoy and impose time and expense on the plaintiff here, which is a much smaller company here. It's a locally owned company with this niche business in the chemical sanitation of animal testing laboratories, and is up against a global company here where that's just one of many businesses that they run. And having read their response, I would say it doesn't mitigate that overreach to say, well, gee, you know, there doesn't have to be any burden or expense. We're willing to just let you not answer and have them all deemed admitted. That doesn't seem an appropriate way to deal with this either. I will say it's not just the sheer numerosity, although that certainly, I think, on its own justifies the protection we seek here. But frankly, these requests are irrelevant and pointless pretty well across the board in any case. There are literally hundreds of requests, close to 1,000 by my count, that ask the plaintiff to admit various versions of you are not aware of X or you don't know X related to the allegations of complaint, which obviously center around Mr. Livingston, who left our employ, who we know because you previously ordered him to return things, possessed somewhere around at least around 300 of our business records for the first several years he was working for the defendants, and which is now the subject of our efforts to obtain discovery from them in terms of whether and how and to what extent those things may have been accessed or used in the competing business. And Your Honor, you recognized at one of the prior hearings in response to some similar comments and arguments from the defendants that, you know, of course the plaintiff doesn't know precisely what the defendant did with these. He was the one who had them. He's the one who knows that, and we're trying to determine through discovery. But to ask in the middle of discovery, admit that you don't know what he did with these, admit that you don't know that he accessed them, admit that you don't know if or how he disclosed them, it doesn't do anything to shed light on any issues that matter in the case. I mean, in the middle of discovery, just like they copied and pasted 350 pages of pattern questions, you know, at best we could copy and paste 350 pages of pattern answers saying, you know, no, we acknowledge we don't know what he did, but discovery is ongoing or something of that nature. That simply wouldn't make any sense and does nothing to advance discovery in the case. Hundreds more of the requests are directed to seeking admissions that various documents are trade secrets or don't meet elements of a trade secret claim in Michigan, even though, as the defense correctly note, the plaintiff isn't asserting a trade secret claim here. The record's clear. There certainly was a Michigan uniform trade secret count in the original complaint. We learned a lot after you ordered the defendant to return our property, and we filed an amended complaint, contract and property-based claims, conversion claims. So hundreds of requests for admissions over claims and elements of a claim that the plaintiff isn't even asserting, likewise do nothing to advance discovery in this case. And so for those reasons, and again, I circle back to just the sheer numerosity itself, I think on its face, lays bare the intentions here. This is not a discovery request that the plaintiff should have to answer, the 1,722 requests for admissions. You have, under the authority we cited, broad discretion to enter a protective order in this case, and we submit that the one that's appropriate here is the simplest one, the one that's the very first option under MCR 2.302C, which is simply that this particular discovery not be had, and that you order that the plaintiff is not required to respond to this set of requests for admissions. Thank you.
Thank you. Mr. Eldridge?
May it please the court, Your Honor, good afternoon. Well, admittedly, 1,700 requests to admit is a lot, and admittedly it is.
Okay, wait a minute.
You're coming out really.
Yeah, can you maybe turn the, is there something you can adjust volume-wise? You're coming out really loud, and it's almost distorting your voice for the court recorder.
Okay, I tried turning down my volume. Does that help?
Maybe a little bit, she thinks, but not a whole lot. Can you talk softer?
I can certainly try and do that.
I don't know. I don't know what the problem is.
I'll distance myself from my microphone here, Your Honor.
Okay, socially distance yourself from your computer.
If that helps.
Okay, I think that might be better. Go ahead.
Okay.
I'm sorry to interrupt you.
No, that's okay. Thank you. Look, Judge, I'll be candid. The number is large, and it's quite frankly the most requests to admit that I've ever had to propound to an opposing party. There's no hiding that. But there's one singular reason why there are so many requests for admissions, which are targeted, by the way, and I'm going to get to that in a minute. And that's simply because the plaintiff has put so many documents directly and squarely at issue as the very documents that they allege we converted. They put almost 300 documents at issue saying that the defendants either converted them or otherwise misused them and that they're their confidential information. And so we're just simply tracking and asking questions, a handful of questions, albeit, about each one of those documents that plaintiff has put at issue. They've actually doubled down on those documents being squarely at issue, Your Honor. Their complaint, of course, references the 28-point inspection as being at issue. It also references these roughly 300 separate files on a flash drive that was turned back over to them early on in this case. And they've said since then, in their discovery responses that we have received, that those are all still at issue. We ask questions about which ones are at issue precisely and why do you think they're confidential? And they've effectively refused to tell us other than saying simply they're all still at issue. So what we did then is we've decided to craft very focused, handful of focused requests for admission as to each one of the materials that they've put at issue as being allegedly converted or misused. One of those categories, Your Honor, is two USB drives that no one knows where they are, no one knows that they even exist, or what is on them or was on them ever. And we asked a mere 3 requests for admission per those flash drives for a total of 6. They didn't object, they haven't taken issue with the questions that we've propounded through these requests for admission, just that overall they're voluminous. For example, we asked with respect to those USB drives, admit that you don't know what files, if any, are contained on them. This is certainly an appropriate question to ask during a deposition. And so it's certainly appropriate to utilize a tool that's available to us under the court rules to streamline discovery through a request to admit. Similarly, Your Honor, they have placed squarely at issue the 28-point inspection. Thus, it's fair game from our perspective to ask requests for admission as to each one of those 28 points. And we did so by asking a mere 3 RFAs per point of the 28 points. Well, the fact that they put 28 points at issue starts to increase the number of requests for admission that are necessary to get this information. And then the largest category of documents relates to the requests vis-a-vis the USB drive that was turned over that contains, it's almost 300, it's actually 272 separate files that they have asserted have been converted. But yet, apparently, per their motion, they don't think they have to answer any questions about it. And so what we did is we came up with very focused and targeted requests for admission, a mere 6 per file that they've identified at issue. And they are very pointed and focused. Admit that the file, for example, Your Honor, admit that the file X in folder Y on USB device FC55 does not contain trade secret information. Well, if their position now is we don't have we're not alleging anything's a trade secret, then tell us you're not alleging anything's a trade secret, because they're still alleging it in their second amended complaint. And so, Your Honor, what I hear is simply that they don't take so much issue with the language of a request specifically. It's really the volume of them. And the volume is dictated solely by the plaintiff's assertions and responses to our discovery requests. They don't get to say, we want all 300 documents to be squarely at issue, but we're not answering any questions about them. The alternative, Judge, if they don't answer these requests for admission, the alternative is that we would have to depose Mr. Sherman McDonald, their CEO, one of the folks we've noticed up for deposition. I'd be able to ask him all 1,700 questions then, I suppose. It'll be a very long deposition, but I don't think they get to dodge these questions forever. And we're trying to avoid taking a 2-3 day deposition of Mr. McDonald by using a tool that's available to us in the court rules to help streamline discovery. And so, Your Honor, we respectfully request that you ask and you order them to answer each one of these, which are targeted and focused, designed to get to the heart of the issues here. We're still at a loss as to what it is that we converted, other than to say everything, and we're still at a loss of what it is that we allegedly did wrong with them, because they haven't answered those questions either. And we think that they should be obligated to answer these very pointed, albeit voluminous requests for admission. I'll entertain any questions that you have, Your Honor.
I don't have any. Mr. Pacific, do you have any rebuttal?
Just briefly, Your Honor. I mean, I'm still surprised to hear 1,722 requests for admissions described as targeted. But beyond that, you know, what I just heard is, well, gee, tell us if you're not alleging a trade secret claim. I told everyone that, the court and the other parties, when I filed my first amended complaint. There's no confusion about that. There's no confusion about which documents, at least to this date, to our knowledge, he converted. We know what was on that USB device. And when I say we, I don't mean plaintiff, I mean plaintiff and defendants. Defendants has a copy of that in their possession. The only way they were able to create this monstrosity in which they name each one of the individual 300 or so files is because they have those. They have those files. And the question isn't whether they're a trade secret, it's whether they're confidential under the contract. They left that part out when they quoted, they say, well, they say everything is confidential, and then they end their sentence with ellipses. What our discovery response actually pointed out correctly is that those are confidential business records under the terms of the parties' contracts. And they are, and the court recognized that previously, that the contract question is very, excuse me, very different than the trade secret question. The trade secret question is no longer at issue in this case. I think this is sort of a game that defendants are playing and are trying to flex their muscle here a little bit on the smaller plaintiff. And I don't think it makes sense for the court to allow it.
All right, thank you. Well, as we've heard, the plaintiff's position is that this entire set of requests for admissions should be deemed a misuse of the discovery process, and that they are only done for purposes of harassing, annoying, and oppressing the plaintiff, and the plaintiff shouldn't have to respond to any of them. And I would agree that if someone told me that there was 1,722 requests for admission that take up some 320 pages, off the top of my head, I'd say that's an abuse of the discovery process. It seems almost a shockingly large number of requests for admissions. But we have to dig a little deeper than just the number of requests for admissions. I've done that, and I'm satisfied that what we have here is a problem of the plaintiff's own making. So the real problem is that either the plaintiff legitimately has a claim that 300 business records on that USB drive are the plaintiff's confidential business information, or the plaintiff's refusing to narrow its claim by conceding that not all the documents are confidential. Now, the former claim that all of them are confidential, I would have a little more sympathy and leniency towards the plaintiff on believing that, except that the defendant gave me a little peek into what some of these documents are. And this is what the defendants tell me, material safety data sheets that the plaintiff routinely disseminates to its clients, competitors' product labels and product sheets, competitors' product labels and product sheets, a template introductory letter without any client information, and clip art labeled PPE with bad glove. So there's at least some in there that doesn't seem any way, shape, or possible to me to be confidential business information. But even if there is some, and I'm not going to preclude that, there certainly could be some. If the nature of the plaintiff's claim, and they refuse to concede otherwise, is that all 300 documents are confidential business information, then shouldn't the defendant be able to ask with respect to each document, do you have evidence that this was disseminated? Do you have evidence that this was accessed? Do you have evidence, the things that the plaintiff is asking basically in the request for admission? As well as, what are you claiming these things are? Confidential information, proprietary information, trade secret information? So the plaintiff says, no, we're not claiming trade secret anymore. Well, I don't think any of us really knew that. And if that is the case, then admit that one. Just admit it. That's the simple solution. And so the request for admission, they become so voluminous because the defendants are asking essentially those same questions that I just described in general with respect to each document. So if it's the latter, though, of my two alternatives, and the plaintiff's refusing to narrow its claim by conceding that not all the documents are confidential, or there's no evidence on some of the documents that they were disseminated or accessed or saved or whatever, if they're doing that, and they've thus far refused to narrow the claim, then answering the request for admissions would force them to narrow the issues in this case. And isn't that the purpose of discovery? So again, I think that this is a little bit, well, no, not a little bit. This is a problem of the plaintiff's own making. And it can be easily solved. And actually, the defendants proposed a very reasonable solution to this, and that is, they said, and the bulk of these requests pertain to the 300 documents. So I believe, if I'm not mistaken, that request number 91 through 1722 are the ones that pertain to the 300 documents and ask basically those basic questions with regard to each. And the defendants proposed, if it doesn't apply, if you're conceding it to narrow the issues here, leave it blank. And, that's a fine solution. But I think that, one of these things has to be true, and either one of them being true, the defendants are entitled to have these answered. So, yeah, you do a little bit of a deeper dive into what these 1,700 and some requests for admission are about, and it becomes a little more obvious that these go directly to the issues in the case. And they are not done, in my view, for purposes of harassing, annoying, or oppressing the plaintiff, oppressing the plaintiff. And the plaintiff could easily solve this problem, and could have solved it, actually, by the proposal from the defendant. So I am denying the request for a protective order with respect to the request for admission. And that takes us to the other request for a protective order, and this is really a protective order that everyone agrees to except for the one provision. And
Yes,
that's also, Mr. Pacific, your motion.
Yeah, and I'll be brief here because, as you noted, this is an area where really there's general agreement to the need for what we often call a blanket protective order to allow the parties to designate things as confidential and limit to use for this case and so on. The only real sticking point is the defendant has indicated that they want a ability to designate documents as attorney's eyes only, broadly built in to this protective order. And we've cited, and there's not a lot of case law on this, frankly. I mean, it's not something that comes up a whole lot, which I think speaks to the notion that this is standard or routine in and of itself. But the case law there is out there and that we've cited, I think, persuasively indicates that there's a high bar for attorney's eyes only designations, precisely because of the limits it puts on litigants and on counsel's ability to communicate with and counsel their litigant clients. Whenever there's an attorney's eye, and here we don't know what, if anything, would be labeled attorney's eyes only, but whenever that label is applied, it means that you now have a party who is in the dark about what the facts and evidence, or at least that portion of the facts and evidence in their case is. You have a lawyer who can't discuss that with their client, advise them of how it affects the merits of their case or the other party's defenses, or frankly, how it would affect mediation or other settlement discussions, which are an important factor in any case. So the cases that we've cited here from the federal courts in Michigan, we couldn't find any Michigan case law. I think defendants found the same, but certainly address those facts. I think persuasively lay out those policy considerations and say that we'll only typically have an attorney's eyes only provision where there's some specific showing of certain records that are entitled to that protection. And here the defendants candidly acknowledge that they don't anticipate using it, at least in the short term, only that they could envision a scenario where it might be necessary in the future. And so I would submit that that's not enough. We've seen previously, and I was surprised to see defendants take the position that we were somehow being inconsistent or something of that nature because we had previously asked for AEO protection. And my recollection, I went back and confirmed it in our correspondence, was that the early protective order we had when the thumb drive was returned and there were some AEO provisions included was proposed by the defendants, not by the plaintiff. There was a concern expressed to me back then by defendants counsel that Mr. Livingston had some personal information, some financial data that was personal to him and things like that were on that thumb drive. And so that was the genesis of that AEO order. And so I think the parties have demonstrated that where it's appropriate, they can easily cooperate and address those issues. But the defendant here has the burden, I think, asking for this extraordinary provision to show why it should be prospectively applied in a case where, at least as of now, they say they can't even identify anything that merits that protection.
All right, thank you. Mr. Eldridge?
Thank you, Your Honor. Admittedly, this is a new one for me as well, Your Honor. I've quite frankly never had to fight with opposing counsel over the insertion of a AEO option that is so commonplace in protective orders in these sorts of cases. And I'm a bit surprised we're here. And it seems to be a bit of a manufactured dispute to kind of delay discovery production or otherwise try and use discovery as a way to go on a fishing expedition for competitively sensitive information. We've been ready to produce documents marked confidential, just confidential, not attorney's eyes only, for almost 4 weeks now when we proposed our language to a protective order. And we've produced 1,600 documents, Your Honor, not marked confidential or otherwise in response to discovery. Plaintiffs have so far produced 0, asserting that every single page and piece of paper that is responsive to our discovery is somehow confidential. But we're fighting over an option in a protective order that has not even been invoked yet. We're anticipating perhaps needing to invoke such an additional protection. And if we do so, we will do so in good faith, and we will do so in accordance with the case law that even Mr. Pacific cites in his brief, knowing that we have a burden to show that something is entitled to extra protection. But we're not there just yet. But we propose the attorney's eyes only provision, again, which is commonplace, as recognized by the Knight decision that we cited out of the Eastern District of Michigan, Your Honor. In an attempt to avoid having to come back in piecemeal fashion to this court seeking protections as disputes come up over particularly sensitive documents, which we anticipate happening. Given the broad discovery requests that we've received so far. For example, we've been asked to produce internal marketing materials and online search engine optimization terms that requests that we don't understand how they're necessarily related to the specific claims at issue. But internal marketing strategies and procedures are particularly sensitive. Now, we wrote back and objected and said we'd be willing to meet and confer to talk about why that sort of request might yield relevant information or otherwise be discoverable. We haven't heard from Mr. Pacific in that regard. He hasn't taken us up on our offer to meet and confer. But if he does, and if he were to press it, and then if he were to press it again, and as it relates subsequently to another discovery request where we respond with the same sort of response, I can envision a point where we would be coming into this court multiple times, filing multiple separate motions for protective order. But we're not there yet because they haven't pressed it. But we're trying to streamline discovery and facilitate the exchange of discovery without having to bother this court more than is necessary. And that's why we did it. Now, these are commonplace, and they're so commonplace that as Mr. Pacific just acknowledged, the parties have already entered into a protective order that allows for the designation of attorney's eyes only material. And the only party that's designated anything to date as attorney's eyes only that's a business record is the plaintiffs. Every single one of the 300 documents that we just talked about on that USB drive, they've marked as attorney's eyes only. Now, we haven't objected to that yet, and we will be objecting to that at some point soon. But they've invoked it. And so what I hear is them wanting to be able to play by different rules. They get to invoke attorney's eyes only to protect their confidential information, but they don't want us to have even the option, even though we haven't even invoked or said we were going to invoke the attorney's eyes only provision. Again, we're trying to avoid fights, and we're trying to create discovery efficiencies with our proposal, and we think that's what it does. Now, more importantly, as importantly, I think, Your Honor, plaintiffs may not realize it, but I think they need the protective order that we proposed with the attorney's eyes only provision just as much as we would like to have it. The reason I say that is because our proposed protective order with the attorney's eyes only option also contains a provision about how to deal with attorney's eyes only material during a deposition, which is, again, pretty commonplace in these sorts of protective orders, so that everyone's clear how it's going to be treated. Well, the November 2019 protective order that the parties entered into when we initially exchanged the flash drive doesn't contain any language or provisions about how to deal with that attorney's eyes only designated material. And so we're going to run into a problem pretty soon here about how we deal with those documents during a deposition when the current protective order says nothing about how we deal with attorney's eyes only provisions in a deposition. We're going to be deposing, as I mentioned, the CEO and other folks over at Sanitation Strategies in August. I got to be able to ask them questions about those 300 documents if they're still at issue. And what I hope I don't run into is some sort of objection that, well, they're attorney's eyes only, and there's no protocol for how we deal with the deposition or the deposition transcripts discussing those. Our proposed protective order sets forth clearly how to do that in a very routine way. And I think both parties really need that provision for that reason. Again, what I don't understand is, and I didn't hear from Mr. Pacific, is why the proposal for unequal treatment between the parties in discovery, why one gets to take advantage of an attorney's eyes only provision, but we may not even have the option to invoke it. I'd like to address the case law just briefly, Your Honor. I agree with Mr. Pacific on this point on one thing, and that there is a bit of a dearth of case law in Michigan on dealing with attorney's eyes only, at least in Michigan state courts, dealing with attorney's eyes only provisions. We managed to find a case that we think is a little more similar to our circumstance here, which we cited, which is a published decision out of the Eastern District of Michigan, called Knight Capital Partners versus Henkel, 290 F sub 3rd 681 from 2017. And in that case, there was no production had been exchanged yet. And the court found it faced with a very similar set of circumstances where the parties were really just disputing whether to include that AEI provision as an option altogether. They were not fighting over a particular document that was labeled or was intended to be labeled as AEO. I'm sorry, I said AEI, I meant AEO. The court simply was being asked to decide whether that made sense to put it in there as a somewhat prophylactic measure. And the court said, yes, it's appropriate in these sorts of cases, and in fact said, quote, it's a routine feature of civil litigation involving trade secrets, end quote. Well, this is a case that's very similar. Up till today, we thought trade secrets were still at issue. But it's certainly a case involving two very intense competitors trying to exchange or trying to litigate over what are competitively sensitive materials. So the logic applies here. But what the court also did in the Knight case is just rejected out of hand this kind of bald assertion and concern by the plaintiff in that case that the defendant was going to somehow just abuse this AEO option throughout the discovery process. And the court said, well, that fear alone is not enough to not have it as an option when it can help facilitate discovery. So the court allowed for an ordered a protective order with the AEO option included in it. And what the court highlighted is that, and what convinced the court to reach that conclusion in part was also the fact that built into that protective order, like ours does here, Your Honor, is a mechanism to allow the receiving party to challenge the AEO designation if they feel it's appropriate. The case law cited by plaintiff, in contrast, Your Honor, is distinguishable. And in those two cases, these cases are Federal Mogul Motor Parts Corporation case from the Eastern District of Michigan, unpublished, and then separately the Arvco Container case, unpublished from the Western District of Michigan, where in both instances, the court there was actually faced with deciding whether a particular document or piece of data that had actually been marked as attorney's eyes only or was intended to be marked as attorney's eyes only was worthy of the attorney's eyes only designation. And the court in those two cases said that those particular documents were not worthy of the designation because the designating party had not brought forth sufficient evidence to call for that extra protection. Well, again, here, we don't even have a particular document at issue. We're just trying to create discovery efficiencies, so we don't think that case law is of much utility to your decision here, Your Honor. Your Honor, I'm not going to belabor it. For all those reasons, we are asking that the court enter the protective order that we had proposed in our exhibits and that we actually have already signed that includes the attorney's eyes only provision in an attempt to avoid having to come and fight in front of you again, Your Honor, on a piecemeal basis. Thank you.
Thank you. Mr. Pacific?
And just briefly, Your Honor, this notion that somehow the plaintiff is taking an inconsistent position by purportedly seeking AEO protection while opposing it here is just not accurate, not supported by the record. The order that was entered was requested by defendants, and both sides operated under that order. But I mean, who's kidding here, Your Honor? The idea that the attorney's own protection somehow protects us from defendants seeing our documents now, they were the ones who had our documents. They were the ones who gave them back. Troy Livingston, the one who produced that USB drive. I see Mr. Eldridge shaking his head, and I don't understand why, because Troy Livingston was the one who produced that thumb drive to us. He had that in his possession for the last 3 years. So we aren't protected in any way by that attorney's eyes only provision. He's seen everything that's on there. He was the one who produced it in response to your order and the one who possessed it for the last 3 years. And despite all the argument, I still come back to one of the first things that Mr. Eldridge said, which is that they've purportedly been ready to produce documents for weeks labeled confidential only, and yet they've been holding up that production to insist on an attorney's eyes only provision that they don't even claim covers any of those documents. I don't think that's appropriate, Your Honor, and so I'd ask that you enter the protective order that is attached to our motion, which the parties otherwise agree upon, and which includes, by the way, some edits that were proposed by defendants' counsel. We incorporated all of their proposed edits other than the attorney's eyes only provision.
All right, thank you. Well, the dispute here is a very narrow one. Both sides agree that a protective order is needed, but the plaintiff doesn't want any reference to any designation of attorney eyes only, and the defendant wants it as an option. I have had this fight before, even if you haven't, and I've learned something from it. And what I've learned is that often in cases like this, where you have companies that are fierce competitors and you have a dispute over business information, business documents, that there is a need in some situations in that case for an attorney's eyes only provision in a protective order. I've also learned that having a blanket, you can designate everything as attorney's eyes only, or having no standards or challenges built in for that designation is presenting a situation where litigation just becomes unfair and unworkable. So I think the middle ground is the best ground to take, and it's the one that the defendants have proposed, which is having it as an option in the protective order. The plaintiffs proposed, the defendants, pardon me, I don't know why I have that problem in this case. The defendant's proposed protective order has both a standard written into it, that standard being a reasonable belief that the material is competitively sensitive, such that it's entitled to extraordinary protections without which the disclosure of the information to another person would create a substantial risk of serious injury that could not be avoided by less restrictive means. That's a very workable and legitimate standard, and it also has a mechanism to challenge it. So I think it meets the requirements that the court would like to see in a situation like this where we have an attorney's eyes only provision. I don't think that having it as an option is a danger because, again, there is a standard and there is a mechanism to challenge. And I think also the defendants have demonstrated that they're not going to abuse it because they've already indicated documents as confidential but have not indicated a desire to mark them as attorney's eyes only. But in any event, should anyone abuse it, there is a mechanism to challenge it. So I would enter the protective order that is in the defendant's response brief as their Exhibit 5, I believe it is, which is their red line version of the plaintiffs that has the attorney's eyes only provision throughout. And that takes us to the last motion, which is the plaintiff's motion to modify the scheduling order. Mr. Pacific?
Thank you, Your Honor. We submit here, as is outlined in our papers, that there is good reason to modify the scheduling order here based on at least 3 factors that we discussed in our papers. and that is the effect of the coronavirus pandemic, the amendment of the complaint after the entry of the order, and also the new Michigan court rules requiring initial disclosures prior to conducting any formal discovery. First, I would say that the coronavirus pandemic has had a very obvious and well-known effect on the operation of the courts and the practice of law in our state. I certainly don't agree, as a defendant suggests, that coronavirus was well known at the time of our March 4 scheduling conference, and then was somehow apparently taken into account in that order. As we all know, this situation came on like an avalanche. At that time, there were no reported cases in Michigan. Our national leaders were saying that this was something they were keeping an eye on, but there was no reason for anyone to change their behavior. There was no discussion, certainly at our scheduling conference, or in any of the discussions between the parties or the court about the coronavirus pandemic or potential effects it might have on the schedule in this case. Just 3 weeks later, though, we were in a state of emergency in the state of Michigan. The governor issued the first of these various stay-at-home orders. Court buildings became closed or limited to the public, and lawyers were told that they were not allowed to go to their offices and work. So I think that's had a significant effect on scheduling, really, in virtually every business and industry, and certainly in the legal profession and in the courts operations. Second, the amendment of the complaint, I think, is also a significant factor here. It's, in any case, it's the claims in the complaint and then how the defendant answers those and defends those in their responsive plea that really sets the scope of discovery for what's in dispute and what the issues are. Here, under that initial scheduling order, we filed a timely motion to amend. It was actually quite early. It was several weeks before the time even. It took a little longer because the defendants opposed that, despite the liberal standard, and it took a little longer because unavoidably the court had to reschedule us a couple times as we adjusted to what was permissible and possible under the stay-at-home orders in that situation. The net result of that was that plaintiff filed and then defendant answered the operative complaint in this case as of May 8th is when defendant's answer was filed, which really set the scope of discovery. So at that point, a couple months had passed since the scheduling conference before the scope of discovery was really defined. And then, Your Honor, we couldn't commence discovery. Defendant's counsel certainly called to my attention the fact that the rules that took effect on January 1st required initial disclosures, and those prohibited any other discovery before those were served. And so we agreed to do those. Both sides did those, and we did, in fact, exchange initial disclosures. Those plainly weren't contemplated in the court's initial scheduling order. We didn't have any discussion about that at the conference. The order doesn't contain anything about it. Even the court's form that was in use at the time didn't have a place for it, perhaps because it was a new requirement, or in any event, it didn't. And so both parties followed the rules, made those disclosures, and then served their initial discovery requests. And we're now here with only 6 weeks to go in that initial phase, where we're still working on exchanging and wrapping up the first set of written discovery. And there's simply no good reason here, I would submit, Your Honor, for us to try to have to rush through in the next 6 weeks all of the remaining discovery that's necessary in this case, and all the things that would normally happen after the parties exchanged the first round. Mr. Eldridge noted in his pleadings, we've extended each other reciprocally the courtesy of brief extensions on answers. Those are the sort of things I think the court usually likes to see parties and attorneys engage in. I'd like to be able to continue to do that. We still have some work to wrap up that first set of discovery. There are always issues that come up. For example, we have, when we got their responses, there were 42 documents that they said they produced that just weren't in there. So we followed up and they eventually got them to us, but those sort of things take time. Now, we haven't even seen all of the documents yet. They're going to get our documents, and there's typically issues and discussions that have to take place under the meet and confer rules if there are disputes. As is typically the case, now that we've seen some of their answers, we have some follow-up requests that we will want to serve. There's third-party subpoenas that we'll need to serve. They've identified customers that they've had contact with and who had the contact and what the topics of those contacts were. So we'll be getting out third-party subpoenas with respect to those issues. We obviously are going to have a significant volume of work to do on these requests for admissions. We have experts listed. We still don't have all of their records to get expert analysis and testimony. And we've just started to talk about scheduling the first depositions in the case. I was just informed, I think it was yesterday, that one of the people that we want to depose is no longer an employee of defendants, so that'll take some extra work to get that deposition in. And as is typically the case, I expect that there will be other people that'll be identified in testimony that will want to depose or other follow-up. But ultimately, all of this comes down to, I think, the normal things that happen in discovery. And just for all of the reasons that we've discussed, we're at a point right now where there's still quite a bit to do in this case. And I think it's reasonable to permit, we've requested 120 days. We're not asking for a whole new 6-month reboot, some time to conduct the normal discovery in this case. And so we respectfully request that you grant the motion to modify the scheduling order.
Thank you. Mr. Eldridge?
Thank you, Your Honor. We did not initially say no to the extension request. We simply asked for a little bit more detail and explanation as to why we needed to extend discovery. Because from our perspective, we hadn't seen any impediment to proceeding with discovery, whether it was because of COVID or any other reason. And we asked for that more detail primarily because the defendants, and I imagine this is true for the plaintiffs, is we don't want to prolong this litigation any longer than it needs to be prolonged. We don't want to add unnecessarily to the expenses. And extending discovery invariably does both. And we simply asked for more detail. And the only detail we received was, well, the COVID pandemic. Surely we need more time to engage in discovery because of the COVID pandemic. But when I pressed Mr. Pacific about what exactly about the COVID pandemic has really caused the problem and the need for extra time, I got no response. Instead, we got the motion filed. And your initial scheduling order requires good cause to extend or modify the scheduling order. And I don't hear any good cause. I don't think COVID has not prevented the parties from exchanging written document requests, not prohibited or prevented us from compiling all of those. All of ours has been ready to go, and we produced 1,600 documents already. And the rest of it's ready to go once this protective order is entered. And it's been ready for 4 weeks. I'm not sure what it is that they wanted to do that they couldn't do in March, April, or May before they propounded their first set of written discovery. They certainly didn't notice up any depositions then. They certainly didn't issue any written discovery before May. So I'm not sure what it is that's causing the need to go beyond September 4th, even at this juncture. We have 6 weeks, almost 7 weeks left of discovery, which is a long time to take care of kind of the loose ends that Mr. Pacific just identified. We think we can get all the depositions in August. Just in the last couple of days, we've sent Mr. Pacific all available dates in August for the 4 folks that they intend to depose. And we provided over 10 for each, 10 available dates in the month of August that are available. We've asked for deposition dates of the 4 individuals from Sanitation Strategies side of the ledger that we intend to depose, and we haven't received any response about when people are available. Except we know that they noticed our folks up for August, and we noticed their folks up for August. So it seems like everyone agrees that we're going to be able to take care of these depositions in August. So again, I'm not sure what the need is for the extension. So, Your Honor, we respectfully ask that you deny the motion and keep the September 4th date in place for the discovery deadline for now, just because there's no cause, let alone good cause, being shown for why we need to prolong the litigation or add unnecessarily to the cost of the litigation. Happy to entertain any questions that you have.
I don't have any, thank you. I think that everything that the plaintiff says is certainly accurate, that when the first scheduling order was entered on March 4th, we really didn't have any idea of what was just around the corner. And then the stay-at-home orders started on March 23rd. April 20th, the plaintiff was permitted to file the amended complaint. We didn't even have the last of the required initial disclosures until June 1st. So I think all that is true, and I agreed once I read the briefs with the defendants that still doesn't give me a reason that would be good cause, but I think Mr. Pacific has been a lot more detailed here in oral argument, and I'm satisfied that he has provided good cause to extend the discovery deadline. The only thing is, in the brief, he's asked for an extension of 120 days. Well, the current deadline is some 6 or 7 weeks out. It's September 4th. So to extend it 120 days beyond the current deadline seems like an inordinately long period of time. So I'll grant the request, but I'm going to extend the discovery deadline by 60 days beyond the current discovery deadline, so 60 days beyond September 4th. And then I assume that bumps the other dates, but if you just want to do an order, Mr. Pacific, that reflects a similar extension of your other dates, then I'll sign off on that.
Thank you, Your Honor. I will do so.
Thank you, Your
Okay.
Honor.
Then that's it for our hearings on this afternoon.
If I may, Your
Yes.
Honor, I have one question, point of
Yes.
clarification. On the, with respect to your ruling on the motion for protective order vis-a-vis the request for admission, the plaintiff's due date is next week, I believe. And I'd like some clarification for purposes of the order of when the court's going to order those to be answered. I'm not suggesting it needs to be next week. I just want some clarification as to what the new deadline might be.
I don't think it needs to be next week either. 21 days?
Your Honor, may we request 28, which is the normal time to respond? I think we were prompt in addressing our concerns and,
Fair enough. Fair enough.
No
28
obje-
days.
No objection, Your Honor.
All right. Any other questions before we end?
no, Your
No,
Honor.
Thank you.
All right. Thank you, everyone.
Have a good day.
Um,